Welcome everyone to the Contact Center Compliance Update webinar. All lines will be placed on mute to prevent any background noise. David Kaminsky and Henry Dancer, you can begin your webinar.
Thank you, Darcy. Appreciate that. Thank you, everyone, for attending. Hoping for us in the West Coast, it's still morning. So good morning to those, and those in the East, good afternoon. So I don't know if any of you have joined our TCPA sessions before. So this is actually the third one that David and I have co-hosted together. Co-hosting is being very generous of my influence. David is the star of this. And so I do want to introduce David. And we're going to go through, we have an hour slotted here. We've got a lot to show and a lot to talk about, so I think we'll pretty much fill that hour. At the same time, we do have, if we have some time at the end, I have received some questions that you folks have submitted with your registration, and we'll try to answer those at the end. And if we don't have time, we will answer these questions and put them on our website. And speaking of that, we will also put a recording of the session today on the website as well. So that'll be there in a few days, give it 2 or 3 days. So if some of your colleagues haven't been able to make the session and you'd like to forward that to them, I'm sure that would work out well. So that's kind of the housekeeping ground rules. And like I said, my name is Henry Dancer, and I'm the Regional Vice President of Sales for the western half of the country with Noble Systems. And I've been in the contact center for coming close to 30 years now, and seen a lot of changes. And with those changes comes a lot of new things and new opportunities. And with that, I would like to introduce David Kaminsky. David is a partner with Carlson & Messer Law Firm in Los Angeles, and like I said, we've done a couple of these sessions before. David has been doing this for about 20-plus years, and he focuses on the creditors' rights and the financial services and litigation industry. He's defending banks and credit institutions. He's quite knowledgeable in both TCPA, FCC rulings, and has extensive experience in the multi-district and class action litigation. So David, I see you have some of your contact information, some of your information there as well as a website. So I'd like to hand it off to you. And the kind of the way we're going to work this is David is going to go through most of the slides, and I'm going to add some color, what I see from our customers and some of the things that we see in our trends. So David's going to handle the legal side of it, and I'm going to kind of bring up some of the business situations we see. So David?
Great. Thank you so much. Thank you, Darcy. Thank you, Henry, very much, and thank you, Noble. We have a lot of information to impart to you today, and we're going to actually hit a lot of different things because we saw the questions that you presented. So this is going to be mostly TCPA-centric and focused with respect to informational calls, collection calls, and some of the telemarketing side as well. We're also going to hit on some other issues that you've asked about. Messages, recording. So we've got a lot to impart. We're going to move quickly, but we're going to hopefully be clear and concise. Let's talk about the TCPA and where we are. So we all know that the TCPA regulates and restricts automated telephone calls, and that's outbound telephone calls that your company makes using automated equipment, automating dialing equipment. And again, the law regulates a call made with an automatic telephone dialing system to a cell phone or a pre-recorded message without prior express consent. I'll say that again. A call made with an automatic telephone dialing system, we're going to get into what that is, to a cell phone. And that's going to be, or a pre-recorded message without prior express consent. In other words, you need prior express consent to make the call or to leave a pre-recorded message to this cell phone. And unless you have, and if you have consent to do it, that's your trigger. Manually dialed calls. Again, manually dialed calls do not invoke or violate the TCPA. Okay? So that's always something to think about. You're going to say, well, what is a manually dialed call today? We don't know. We're going to talk about that in a little bit. Again, the TCPA applies to those voice calls, voice messages. It applies to texts, and it actually applies to faxes as well. For those of you who are doing telemarketing also, you've got to look at your do not call lists. That's your national list. Sometimes that's the state list, and that's certainly your company's own internal do not call list for those of you who are marketing. We're going to talk about the FCC and how they've regulated this area and what they're doing, what's going on, and what we can expect in the future. You want to know about all those petitions. I get it. We're going to talk about it. Damages under the TCPA, you know it's insane. It's $500 basically for a negligent call. It's $1,500 for a willful call. That doesn't mean intentional. There's a distinction there, and it's a very loosey-goosey, sometimes standard to find what is a willful violation. Something lower than an intentional violation, but something higher than a negligent violation, and sometimes the courts don't even get them right. Yes, the damages, especially when you're looking potential damages in a class action, when you're dealing with, let's say, millions of people in a potential class, the damages, are, of course, are catastrophic. I mean, look at them right there. Just at a million calls at $500 a pop, you're looking at $500 million. I had a case that I was defending where I told the judge that my client's potential liability for a 30-person small little bank was $4 billion, and the judge realized that this statute is absurd. Let's just give you the overview, okay? What does the TCPA cover? Does it cover residential calls? Well, it sure does. But there are so many terrific exemptions with residential calls that most of you have outs. Telemarketing, slightly different. So if you're making a call via a dialer to a residential call, again, that issue does not invoke potential liability. Calls to residential lines via dialers where you're not leaving messages, just the call itself via dialing equipment, that doesn't invoke liability. It's only leaving the pre-recorded message. As it says right there, if you can see, leaving the pre-recorded voice message. Okay? Again, you can initiate calls, live operators using your dialers without triggering the TCPA. If you're telemarketers, you've got to think about the do not call requirements because those apply both to mobile and residential phone calls regardless of how you are calling. But that's the do not call list. That's different. That doesn't apply to the debt collection arena. It doesn't apply to the informational call arena. Okay? So just remember this. So with regard to mobile phones, your liability is triggered this way. Residential is only triggered generally by the pre-recorded message. The mobile phone, a call to a cell phone, is triggered by either the call itself to the cell phone via the dialer, a text message, or and via dialing equipment. Text message, a call, a pre-recorded message via dialing equipment. That's the trigger. Talk about a dialer. What is a dialer today? What's going on in the case law? What do we need to be thinking about? Okay? Look at this definition again. Again, it's equipment that has the capacity to store or produce numbers to be called using a random and sequential number generator. And most of you on the phone are saying, well, we have some kind of dialers, and I know our dialers don't have random and sequential number generators, so I'm good to go. Unfortunately, the way so many courts have interpreted this random and sequential number generator, some courts are literally reading out that phrase from the statute itself when they're interpreting it. They're not allowed to do so. You're absolutely right, whoever is saying that. But they can't do that, but they do. And the FCC, as you know, came up with its own theory, which we're going to talk about as to what it thinks is a dialer. The FCC says as long as you have the capacity to dial without human intervention, in their opinion, the capacity to dial without human intervention, such as, quote, predictive dialers, as they've already talked about. Those, the FCC has said that they are trying to redefine this definition that you're looking at right now, this 4227B1A definition that Congress came up with. The FCC has tried to, in a subtle way, redefine the entire definition of what is a dialer. It doesn't say anywhere in the TCPA predictive dialers. It doesn't say anything that, oh, what we mean is dialers that have that capacity to dial without human intervention. That doesn't exist. That's an FCC fiction. But yet they've come up with that, and many courts throughout the country, when they're looking at the dialers, said, hey, one just came out the other day. It said, I don't really agree with the FCC, but I'm sorry. I'm bound to follow it. I'm in the 7th Circuit, which is Illinois, Illinois, and this Illinois District Court said, I am bound to follow the FCC ruling. I don't want to. I just don't have a choice. So that's the problem that we're facing. Some courts saying we don't have a choice but to follow the FCC ruling. And yes, they may have sort of bastardized or reinterpreted this auto dialer statute definition that's from the TCPA, but sorry, we got to follow the FCC. We can't ignore it. Again, the FCC said without capacity to dial without human intervention. That was in their 2008 order, also in their 2003 ruling and order. And again, they've said, hey, you know, we think that these predictive dialers you use are sort of these auto dialers. They were not really so concerned with the predictive aspect of it. That's not what they're concerned about. And predictive aspect of a dialer has nothing to do with the TCPA. But they know that those dialers that have predictive capability usually have this automated capability where you can, quote, upload a list of numbers and then program the dialer to dial it. That's what they're concerned about. Let's talk about some of the cases dealing with dialers and what these cases say and how they're giving some pushback. So we've got Dominguez out of Eastern District of Pennsylvania, and let me just qualify something. Terrific decision, at least for the defense. Yes, an appeal is pending in that case, as not yet, yes, our oral argument did already take place, so we're waiting for a ruling. So that's going to come out from the Third Circuit Court of Appeals. But this is the district court version where they said, look, the statute says what it says and mean what it says. The statutory definition is absolutely clear. We're not going to rely on the broader definition by the FCC where they say, you know, uploading a list of numbers is sufficient to qualify it as a dialer. That's not what the statute says. This court said that statutory definition is absolutely clear. They said we're not bound to follow the FCC ruling, and we're good to go. It's a great decision for the defense. The Eastern District of Pennsylvania and the district courts in Pennsylvania are so TCPA, they loathe the TCPA. They are so defense-friendly. It's the best jurisdiction for defense mostly. Yeah, they've given some, you know, rulings that aren't so great. And the Third Circuit Court of Appeals has reversed some of these great district court defense rulings, but it's still a great one. But then we come to another decision against Yahoo that's out of California. And of course, California had to come up with the contrary version. What's interesting in this case, the judge looking at the dialer issue said, you know what, I see some people are advocating to rely on the FCC ruling. Some people are saying, let's just look at the statute. Well, he said, we have the Ninth Circuit decision of Satterfield out here that is governing me. So that says that the statute is clear and unambiguous on what is the definition of a dialer. So he said, I'm going to look at that. He said, but in looking at that, this is what I say. He said the focus has to be on whether the equipment has the capacity to store and dial random and sequential numbers. Again, this judge said the focus has to be on whether the equipment can store and dial random and sequential numbers. Well, that's not what the clear ambiguous statute is saying. So if you're looking at the clear pronouncement of the statute, you couldn't have come up with this, but this judge did out of the Southern District of California. He got it wrong, and a request to challenge the judge was made, and a motion for reconsideration, and he denied that as well. So he took a different philosophy, and he said, look, I think there's an issue of fact here, Yahoo, whether your text message system has the capacity to be a dialer under the statute, because we don't know if it has the capacity to store numbers and then dial random and sequential numbers. It doesn't say dial. It's all about numbers generation. And let me tell you who got it right. A judge sitting in the same courthouse as that Sherman case I just talked to you about, sitting right next door to that same judge, this judge, Judge Bashant, came up with a totally different ruling. And she said, look, I'm going to look at that Satterfield case too, but I think Satterfield says that you don't look at the you don't look at the FCC's definition of a dialer. You ignore it because the Ninth Circuit has said that the definition of a dialer in Congress's TCPA statute is clear and ambiguous. So she said, if I can ignore the FCC ruling, well, let me just look at the statute itself. She said, number one, I think capacity means present capacity. It's not what you can theoretically do and how you can refigure and rejigger your system. It's about what it can do right now at the moment. So right now what it can do at the moment, basically, she said, the system doesn't have the capacity to dial random and sequential numbers. And she says, I think random and sequential numbers have to be taken literally. And random and sequential means number generation. It doesn't mean what you can dial in sequence or randomly. Or she says it's numbers that are being generated by your system. If your system can't generate numbers sequentially or randomly, then you don't have a system that falls within a statute. It's a great ruling. She really thought about this, and let me tell you where she really thought about it. She said, hey, I get the fact that the FCC may have some purview over the TCPA, and they do. She says, but their ability to make rules comes in the 227B section of the TCPA. It starts there, meaning that's the section where it says this is the 227B section is where it talks about it's illegal to make a call via dialer without prior express consent. She says the first part, the 227B1A, that's the definitional section. There's nothing that said the FCC has the right to touch Congress's definitions. So if they don't have the right to touch it, they can't even be doing what they did, is to redefine that dialer definition if the definitions can't be touched. She said again, she thinks she can ignore the FCC because of the Satterfield decision. It gives her that right. But she said even if we were to look at the FCC's definitions, they can't touch the definition of a dialer. They don't even get to touch that part of the statute. She may be very well right. I thought it was a brilliant analysis by her. So I really like this decision. I think it's well thought out, and we hope this is going to be the tenor of the day. Remember, it's only a district court decision out of one court, and as I said, her brethren came up right next door to her in the same courthouse, literally came up with a different opinion as to what is a dialer. So that's just to show you how much weight a particular district court decision is. A court in New York could say, hey, I like what that judge did in that one case, in that Marks case, and I'm going to follow her logic. But he doesn't have to, certainly, and no one in California has to follow it. Let's talk about consent. Consent is, again, always one of the hot-button issues in TCPA. We're going to talk about consent for informational calls, debt collection calls, and then generally mobile marketing, such as telemarketing calls. Let's talk about mobile calls. You always need some kind of consent somewhere to make a call to a cell phone. Again, the residential line, dialer doesn't invoke liability. It's only when you leave potential pre-recorded messages. But again, you have the commercial call exception. Commercial call exception under 64.1200 of the FCC's Code of Federal Regulations for a commercial call exception. If you're leaving basically a business call and it doesn't include an unsolicited advertisement or telemarketing, you're good to go with that pre-recorded message call to a landline, because the court says that that exemption is so broad it should cover calls to debtors and even non-debtors. In many cases I've said that as well. But let's talk about mobile phones. Again, prior express consent is needed for informational calls, customer service calls. Debt collection calls, same thing. You need prior express consent. Can that prior express consent be written? Yes. Can it be oral? Absolutely. Someone tells you, hi, only call me on my cell phone. Please call me on my cell phone. This is the only number I got. Yes, you have consent to call me on my cell phone. Yes, you have permission to call me on my cell phone. Yes, you have permission for any and all purposes. That gives you consent. Marketing calls, slightly different. In October 16, 2013, unfortunately, the new telemarketing consent rules became effective. And for you telemarketers out there, you had to get prior express written consent. It, to me, is the most draconian and hideous law that came out. Unfortunately, that's what the FCC did, and they have that power. But again, it's prior express written consent. Oral consent is not going to suffice. Remember, making a call to a cell phone, you always need some time of consent. Let's talk about debt collection calls and calls by creditors. You've got the FCC 2008 ruling, which basically said, creditors, if you got a number and it's a cell phone number and you got that voluntarily, let's say for an example, in an application for credit, in a credit card application, in a mortgage application, in a sales receipt, whatever that form may be, you have a strong argument that you have prior express consent to call the person at the number called. You've got consent. They don't have to say consent via auto-dialed equipment and all that other language. The fact that they give you and release their number voluntarily, the FCC has said since 2001, you're good to go. And you've got consent. It's a terrific ruling, and then they gave a gift to the debt collection industry saying, hey, debt collectors, if you're collecting on behalf of your creditor and you don't have that consent, and you're using auto-dialed equipment to make calls to cell phones, but your creditor got the consent in the first place, and you are calling on their behalf for debt collection purposes, we're going to say, that's paragraph 10 of that FCC 2008 ruling, that you have consent because you step in their shoes as well. We call that pass-through consent. Okay? For pass-through consent to apply, it's got to be provided to a creditor. Yes, can a debt collector get consent directly from a debtor or a consumer in writing or orally? Absolutely. But for pass-through consent, where the debt collector says, I don't have any consent of any kind, I'm just relying on my creditor and their documentation, and I've got an application from the creditor, and it's got the debtor's number right on there, right in the application. Good to go. Call that number via auto-dial equipment, and you could leave your pre-recorded messages. But just remember about getting consent. The NIGRO case, as you can see at the bottom there, where the FCC actually filed an amicus petition weighing in on the issue in that case, saying that, look, whatever you get consent from someone, you get consent, you've got to look at the context in which you were given that consent. Let's just say you get the consent voluntarily by a cell phone being provided on a credit application. That person should know that within the purview of giving that number to get credit, they're also going to incur bills and expenses, and they're going to have billing statements, and certainly they expect to be called on those for collection purposes. It's part and parcel of giving your number in the context of getting credit. If you take out a mortgage, you know you have to pay your mortgage every single month, and if you don't, you're going to get calls. It absolutely makes sense that by giving the number to a mortgage company on an application, you're going to expect to get calls for debt collection, and that definitely falls within that purview, even if narrowly construed. In the NIGRO case, very briefly, the plaintiff at issue had given his number to a utility company saying, my mother-in-law is deceased, so you need to start closing out her account. If you have any questions I can assist you with, please call me. The utility company started calling him for debt collection purposes and say, hey, you're the responsible person. You gave us your number, so pay the bill. And he goes, I never gave you permission for that. I just said I would assist with the closing of my mother-in-law's account. And why are you calling me on auto-dial equipment? You didn't have permission. I never gave you consent for that. And they said, yes, you gave the number voluntarily. That encompasses calls via auto-dial equipment for collection purposes. And the court said, no. He only gave consent for a specific person to facilitate the closing of that account. So the consent was interpreted too broadly by the company when they made collection calls for payment purposes on an account that wasn't even his. That's NIGRO. Other cases have come down the same way. Again, here the FCC 2002 and 2008 rulings have said the knowing release of that cell phone number, providing that number is consent to call, absent instructions to the contrary. Someone said, here's my cell phone number, but I'm telling you right now, you can only call me in the event my balance exceeds $50,000. Short of that, you can't call me on my cell phone for any purposes. Okay, that would be instructions to the contrary, okay? But if someone doesn't give you any instructions, they just give you the number, it's an open season so long as the consent or what the purpose that you're calling from them is within that narrow consent that they gave you in the first place. Remember that consent is creditor specific. So if someone gives you consent to call them on their GE account and you're calling them on that account, doesn't mean you can call them for every other creditor for which you may have a particular debt that the consumer at issue owes. In that same context, consent is debt specific. Just because you're calling on one particular debt for one creditor doesn't mean you could call them if they have 5 other accounts with that same creditor unless you got consent broadly. Yes, you may call me for any and all purposes and for any and all accounts for which I may have. If they give you that broad consent, absolutely. Make sure that that consent is captured in a way that you can always prove it or document it. And we're going to talk about call recording a little bit later. Very quickly, we already talked about NIGREC, but in Colaneck, what the consumer did is they went into Walgreens. Walgreens said, we need your cell phone number only for the purpose of making sure we don't confuse you with any other consumer or patient when we're giving out prescriptions because people have the same names, and that's our way to distinguish what do we have the right Judy Smith for this prescription. Well, the plaintiff got a text message saying, hey, your prescription's ready. Now, you would think that would go part and parcel with the consent they gave, but unfortunately, the court said it doesn't, that the Walgreens exceeded the scope of consent because they said, hey, we only need this number for the purposes of making sure that we've got the right identity. Well, they called for prescription-ready purposes and left text messages, and they got dinged. So again, consent needs to be looked through narrowly. And the Kolinek case, oddly enough, came out before the Nigro decision, so before the FCC even weighed in on this issue. Let's talk about timing of deemed consent. And I'm sorry, I'm just looking at this picture here, and I'm thinking, what in the world does this have to do with consent? We have a woman there giving her husband a pot of soup there, and he's rejecting the soup because he doesn't like her cooking, and he proceeds to, I don't know, shoot her with a laser gun. So what this has to do with consent, I don't know. But basically, consent, let's talk about the timing of consent. It's deemed provided only if the consent is given to a creditor, and the FCC said during the transaction that resulted in the debt owed. But guess what? The FCC really didn't mean literally at the time of credit card initiation, the minute that they put their number on the credit card application. It doesn't literally have to be at that moment, and many courts, including the Ninth Circuit in Meyer on this page, have said that you don't have to have consent the moment you take out that credit card application. No, that's not what we meant. The FCC also said 3 times within their 2008 ruling, as long as the number is given in connection with an existing debt, you're good to go. And the Ninth Circuit in Meyer amplified that by saying as long as consent is given before the call in question is made, you're good to go. Okay? Consent, how do you get it? It can be verbal, in writing. Yes, giving it on a website with a check mark, that's consent. You can capture consent that way for you telemarketers. Yes, you know that's a great way to get that consent because consent today for the telemarketers we're going to get into, you have this checklist of everything that you have to disclose to a particular consumer. If you're doing it on the website, they've got all the information in front of them and they check the box, yes, I agree to everything and here's my cell phone number. Great way to capture consent. And you've got the evidence. That's evidence, and that's so key in capturing consent. Looking at the Smith case, you got a number that you put on an loan application, good to go. That's what the FCC has said for years. Putting the number on an application, a credit card application, loan application, mortgage application, sales receipt, good to go. Can consent be given, again, directly to the creditor, debt collector? Absolutely. Orally in writing? Yes. Telemarketing must be in writing. What's not consent? I think all of you know this. Capturing consent on caller ID absolutely is not consent. You don't know. The person may give you consent, but you're not going to know it. If you see something coming up on caller ID, the best thing to do at that moment is to say, hi, I see your number is so-and-so. May we call you at that number for any and all purposes? Yes, you may. Can we call that number for any and all accounts that we may have in our office for you? Yes, you may. That's my only number. Please call it. And, of course, if you have that call recorded, my God, then you've got the evidence right there that you can always turn to. Of course, keep that recording for a long time. We'll talk about that later. Someone tells you, don't call me your number, just honor that. Anyone who says, do not call me, I don't care if it's writing, I don't care if your terms and conditions expressly require it to be in writing. Yes, you may be able to stand on that and win in a court, but you don't even want to have to get there. When someone says, do not call me, honor that. I don't care that it's orally, it's not in writing, because what you're going to get if you don't is the angry bird who said, I told you not to ever call me on my cell phone. And what that person does when they get angry, it's a march, clop, 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 over to their attorney's office to start a lawsuit. You don't need to pay $50,000 to prove that you were right. Let's talk about skip tracing. Of course, you skip trace numbers. Don't ever load them into phone fields, which can be picked up from a dialer until you know you have confirmed consent to call that number. Even if the skip trace number matches the data that you already have in your phone database, that's great to go as long as you can prove that the number that you had in the first place is a number that you can prove that you had with consent to call the consumer or debtor. And the crux is with consent, If you want to prove consent and demonstrate it, demonstrate that you got it from the horse's mouth, from the application, from the consumer directly. And you say, not only do I have the application, but I got the recording where they told me on the phone call, absolutely call me only on my cell phone for any and all purposes. You've got it. You're good to go. Who's responsible for proving consent? This is always a hotly debated issue. But most courts and the FCC has said, look, it's going to be the creditor's burden to prove that they have consent. If they're relying on consent because someone put their number on an application, then they're going to say, creditor, prove it. How can you do it? And you, debt collector, collecting on behalf of the creditor, you're going to have to prove it as well. And they said, creditor, if your debt collector is calling on your behalf and they got consent from you, creditor, because they're relying on the application you gave to them as their basis for consent, not something they got independently, well then, creditor, you're potentially on the hook here. In other words, they're imposing almost vicarious liability by the statute. And let me tell you, there's nothing in the TCPA statute that imposes vicarious liability. We're going to talk about this later, but yet the FCC did here. Let's talk about what happened in this Mays case on the issue of consent in the medical context. And I'm going to give you just a short version. You're going to get these PowerPoints after this session is over, and Noble's going to provide you this PowerPoint. There's a lot of detail that I'm not going into, but you've got it all there, and you could review it later, and you could see all the detail. I'm just giving you the highlights so that you know what is the tenor of where we're going, what is the tenor of the state of the law right now. This is a great decision out of Mays, but to be honest, it was the only decision they could have done because it was the right decision. Basically, the Mays said, look, in a hospital context where maybe someone comes into the hospital, does the intake through the hospital, and then the hospital passes all that information down to any other providers within the hospital, the radiologist in this case, the lab, et cetera, the emergency room. This court said, look, there's some context where giving an intermediary consent works and makes sense. The FCC had already issued a ruling regarding intermediary consent being proper in a social media context. So they said in certain circumstances it could. And what the court said here, the reason why they also like the intermediary being the hospital, capturing consent at the outset and being able to pass it down, the hospital's documentation was terrific here. They gave notice in their privacy statement that said, hey, we may disclose your information to the radiologist, to the emergency department. So plaintiff was already on notice, and they said it could be for health purposes, for treatment purposes, and for bill collection purposes. They also said, hey, we may disclose your information under HIPAA to business associates who are going to perform agreed upon services and billing to you. So they gave all these great disclosures. And that really helped, I think, the 11th Circuit here to pave this way that sometimes an intermediary, such as a hospital, will get the consent and can pass it through to others, and it makes appropriate business sense. The question is, in this case, is it going to be specific and limited to, quote, having that documentation that was in addition to the court saying the intermediary can capture consent here? Would they have come up with that ruling if the documentation from the hospital didn't say we are going to share this with others for these reasons and these bases? I don't know that answer. None of us know. It is a great decision, and for all of us in the medical context, and I collect medical debt, I defend companies who collect medical debt all the time, and I'm using the Mays decision. I've been doing it with some success. It's been pushing plaintiff against the wall in many cases. Some of them say they want to move forward, and they think that decision is very narrow. But I've been able to use it as a great sword to get rid of TCPA class action in the medical debt context. October 16th rules, very quickly, we talked about them briefly. This is a game changer for the telemarketing industry. As of October 16th and forward, verbal consent, no longer good to capture consent to call on cell phones via auto-dialed equipment and to leave those pre-recorded messages. You now have to get this prior express written consent, and it's terrible and draconian. Let me show you a list that I'm going to share with all of you. I call it my 7 points of light. It is my Bible. It literally sits up with me when I'm dealing with my telemarketing, non-informational, non-debt collection clients, non-banking clients. And this is the checklist that I use. And these are all the elements that need to be in any disclosure that someone is going to sign off on to capture that October 16, 2013 telemarketing consent. It's all of these issues. You've got to disclose who the specific seller is that you're going to be calling for. You've got to have the consumer identify their number. They're going to have to say, I agree to all of the foregoing. So you've got to get them to affirmatively agree. Disclose that the consumer is authorizing us to engage in advertising or telemarketing. That, i.e., I'm going to offer you products, goods, and services, and you're okay with that. Disclose that the call is going to be made using automated telephone dialing systems, text message, email, etc. Yes, email is not covered by the TCPA. Never hurt to throw it in. It just covers you. Disclose that the consumer is not required to provide consent as a condition of purchasing any goods. And just remember that you can capture the written signature through an e-sign. That's through electronic means. And in some instances, a recording can suffice. But remember, there's permutations with that. Too many to go into this. I deal with many of my clients on the telemarketing compliance side, as well as I do compliance with regard to informational and debt collection calls. Telemarketing, very simply, how do you know I'm telemarketing? Well, you're telemarketing if you're going to advertise anything. If you're going to initiate a telephone call for the purchase of encouraging anyone to purchase rentals, investment in property, purchase of goods, purchase of services, that's going to be transmitted to any person. But you can always distinguish a telemarketing call, an advertisement, from a purely informational call. It's simple. Purely informational only imparts information. We're trying to fit debt collection. We've been arguing with the FCC that the debt collection calls should be considered purely informational. FCC says, gosh, they think they're a hybrid on their own, but we've been arguing they only impart information. There's no upsell there, so it's clearly not telemarketing. They just don't know which bucket to put it in. Purely informational is the school closing, the fraud alert, the bank calling you and getting fraud. There is a petition right now that the FCC is looking at to exempt any purely informational fraud alerts that come from banks, ID theft notifications, because consumers want to know that information. It's what they expect. It's desired. And everyone wants to know the second it happens if they're a potential victim of fraud. So they're trying to get an exemption. I cannot see the FCC not granting that in favor of any of the industry who's going to send out a fraud alert. That should be exempted. It's crazy that it's not now. Look to calls that have a dual purpose. Let me just tell you about this Chesbro case at the bottom very quickly. Best Buy said, hey, your reward points that you have with us are about to expire. You don't want them to do that because you'll lose them all. So come into our store and do what you need to do to keep them going. Well, what they needed to do to keep them going is to purchase something so that it didn't expire because there was so much inactivity. So that was not only informational, but it was also an upsell. The Ninth Circuit Court of Appeals said, sorry, this is a telemarketing call because part of it was not only to inform them that they would lose their points, but also to give them the upsell as they come into our store and buy. What about, let's just say you captured consent in writing, you telemarketers, and you got it before October 16th, but it didn't have all the points in my 7-prong points of light, my 7-point checklist. Can you still get consent? Do you still have consent because it's grandfathered in? This is an issue that is the subject of a heated debate right now. There's an FCC petition right on there saying you must grandfather all of those prior consents that we telemarketers obtained in writing previously, because there's no other way to, how can we go reinvent the wheel and start capturing it from thousands to hundreds of thousands to millions of people from whom we've gotten consent in the past? It makes great sense. The FCC should rule on that and should rule quickly. We're begging for it. Right now, that is not the law. But at least look at that Lambert case that I'm citing. That case said, look, this issue was so hot and so important, and because the case before me is invoking telemarketing consent, I'm going to stay this entire case because the resolution of the FCC petition will impact this Lambert case. And that was a great decision by the judge. So always think in the telemarketing context, if you're facing a class action or even just an individual action, think about staying that case pending the resolution of that FCC petition regarding grandfathering and prior express consent. let's talk about revocation of consent. Always a hot issue, but as I told you before, someone revokes in writing, just honor it. Gager case here from the Third Circuit Court of Appeals out of Pennsylvania said, look, consent can be in writing, it can be orally. Look at the bottom of the screen. Osorio from the 11th Circuit Court of Appeals, which governs Florida, Georgia, Alabama, says, hey, we believe it's okay to revoke consent orally or in writing. We agree with Gager. We said absent instructions to the contrary. And what do they mean by that? You have a credit card app, terms and conditions. This person acknowledges that they're bound by the credit card. They got their credit card in the terms and conditions at the same time. Well, then you've proven that they've got the terms and conditions. If those terms and conditions say you can only revoke your consent given to call you in writing and upon receipt and acknowledgement by us, if that's your terms and conditions, guess what? A court could rule that a debtor is or a consumer is contractually bound by those terms and conditions. This issue has not yet been tested before the courts. And courts can go either way. Maybe they'll say, hey, that's not prior express consent because you have it hidden in your terms and conditions. Other courts will say, wait a second, this is a contractual provision. You're bound by the credit card, you're using the credit card, and you agree to the terms and conditions. Sorry, you can't revoke your consent unless it's in writing, just as the terms and conditions say. But I would never rely on that. It's just a safer protocol. Someone orally revokes consent, honor it, document it immediately in your system so that number can never be called again by auto-dialed equipment. And if someone says, don't ever call me again, just honor don't ever call you again, because that means they're probably not paying on that debt, and it's easier either to do what you need to do if you have the right to sue them, or move on to other files because you've got the files and you've got other matters to worry about. Reassign mobile numbers, you know what those are. Those are those numbers that you had consent to call in the first place. You can document it and prove it, but somehow that number was reassigned to someone else because the original consumer or debtor gave up that number or lost that number because they didn't pay their Verizon bill. So it got reassigned to someone else, and that reassigned person says, hey, I never gave you consent. You called me 50 times on my cell. I can sue you because you didn't have consent. Most courts are saying that the person who is the subscriber to the cell phone number has the right and standing to sue under the TCPA. And some courts are saying, hey, we don't like it, but that's what the law says, and that's what the TCPA basically says. They're looking at the word called party, and a called party is, we're saying it's a subscriber, so any subscriber who gets a call has the right to sue. We understand it's a reassigned number. This very issue is subject before a petition before the FCC. And hopefully the FCC will get wisdom and grant the exception that so many industry are asking for, which is, wait a second. If you got consent from a person in the first place, that consent should remain with that person until they give it up. So until we have information that the number we're calling does not belong to that original consumer, we should have no potential liability. Please, FCC, give us an exemption for this reassigned number issue because we have no way of figuring out, there's no technology that can tell us conclusively that a number is being reassigned to a new person and when temporally they got it. We're hoping that's going to come into play. For you telemarketers which consent, remember, you may have consent, you may have it on an application, you may have post October 16, 2013 consent, but if that person is also on the DNC list, I would honor that list and follow that list, scrub against the national list, the state list, and of course your company's own internal list. When someone says, don't call me on the phone, put them on your own internal list so that you're covering yourself all these different ways, okay? Very, very important. And remember, both residential numbers and business phone numbers and mobile phone numbers can be registered on the National Do Not Call Registry, right? So remember that. But business telephone numbers cannot be registered. So Verizon or the Kmart down the street cannot list their number on the DNC list. It's only residential and phone numbers from consumers. You're not going to find business numbers on there, or if they are, they should not be on there. Let's just talk briefly about vicarious liability. I want to get to some of the questions that all of you have posed because they're important. The courts are saying these days, look, vicarious liability, we're saying, let's talk in the TCPA and then we'll talk in the non-TCPA context. In the TCPA context, we're one court is saying here, this Dish Network petition, there's not an automatic right to vicarious liability, meaning where someone is liable for the conduct of another just because of the position that they hold. The TCPA basically says that you are liable if you make calls. Part of the telemarketing part of the TCPA calls that saying you're liable if you make calls or make calls on behalf of another. The person on whose behalf you're making them can be potentially liable. But the FCC said, look, there's no automatic right to third-party vicarious liability. If, let's say, A is the creditor, B is the person that's making the call, the FCC is saying A is not going to be automatically liable, but they could be liable on a vicarious liability theory based upon a theory of federal common law and state law. What does the state say about vicarious liability? What does the federal common law say? And most of this resolves around the word of control. Did party A control the conduct of party B in calling? Did they direct them? Did they have the right to control them? Did they tell them what to do and how to do it? That's where the whole vicarious liability issue is coming in. Bad decision out of the Ninth Circuit Court of Appeals, Gomez decision, October, so it's a recent decision. That court said this. That situation was this. Navy hires a marketer to say, hey, marketer, please do a marketing campaign to all these people who we want to sign up and become, members of the Navy. And so marketer hires a third party to do that, a third-party vendor to send out the text, because the marketer doesn't have the capability. The Ninth Circuit said, marketer, the Navy gets a pass because they have immunity under federal law. But you, marketer, sorry, you hired the text message company, and basically you had the right to control them. You didn't direct how they did the calling and whether they scrubbed for cell phones against the do not call list or or just to determine if the number is a cell phone. They just called willy-nilly, and you didn't do anything. You had the right to control them, and you didn't. So we're going to say that liability flows uphill. It's a very, very broad decision by the Ninth Circuit Court of Appeals, which governs all of the federal district courts in the states within the western region. You've got California, Hawaii, Arizona, Nevada, Alaska, et cetera, et cetera. So the Ninth Circuit said basically, look, that defendant, you hire someone to do your dirty work, and if there's some kind of agency relationship there, and we're going to interpret that broadly under federal law, well, guess what? You have potential third-party liability. They also expanded the third-party liability to any person. Basically, it's persons and entities that could be potentially vicarious liability for making the telemarketing calls. And the court also said, you know what, we're not limiting these calls to telemarketing calls. It's any calls under the TCPA. That's what the FCC Dish Network ruling says. It's not limited to the telemarketing context. So, look, it's open season with regard to this. You also know that Director Cordray from the CFPB says, hey, creditors, we're gonna make sure that you manage your service providers. We're gonna make sure that you examine and analyze all of their contracts, that you review them, that you go over them, that you know what's in them. You cannot take a blind eye. Well, if the CFPB is making creditors and overseers oversee their servicers in this regard, that's imposing facts and duties and obligations that could give rise to and invoke potential vicarious liability. That's very, very dangerous. But that's what the courts are doing. I want to get into some questions very quickly here. I just want to tell you about some hot button cases that came out in the TCPA context first. So, look, there is pushback. There is pushback on the TCPA. We had a terrific case called Ballschmitter, and Ballschmitter came out recently. It was a case out of the Eastern District of Wisconsin. And the court said this in the context of TCPA. The court said, look, I think that, over a 4 to 5 year period in which a class would be relevant in a TCPA class action context, you've got thousands of numbers and sometimes millions of numbers over a long period of time. How do we know that those numbers weren't reassigned? Who has the number? Who got the call at a given time? This court thought that there was a real problem in ascertaining who the class members were, and said, plaintiff, you have proposed no realistic way to do this, to say who are our class members and did they get the calls, et cetera, et cetera. So the court said, I think this fails the ascertainability prong of class action analysis, and I'm not going to certify the class. Also, the court said, we believe that the issue of consent here, because TD Auto Finance get so many of the only way they said they get their numbers is via applications or via direct consent. So they said, well, gosh, the court said you could produce thousands and thousands and thousands of records of evidence of consent, and what you wouldn't have consent for, we think, would be an individual inquiries to every single, application to see if they did or did not give consent, or every single account. He goes, that's crazy and that's ridiculous here. But what I've got to tell you is when we see some of these terrific defense rulings, sometimes it is because the plaintiff has not done their job here. This plaintiff bought off way more than they could chew and didn't really know what they're doing. Clearly not some of the most sophisticated plaintiff's lawyers in the country, and could have handled this completely differently. And even the court hinted how the plaintiff here could have done something differently that may have gotten them out of this mess that they're in. But otherwise, I mean, this is a terrific ruling for the defense. But this plaintiff bit off too much they can chew. There's a lot of smarter plaintiffs who will start off with a national class of everyone that you called from the day that time began, and I'm being facetious, of course, till the time that class certification is ordered by the judge. But that's too much to chew. The smarter plaintiffs are drilling down in your discovery and drilling down and drilling down and drilling down till they get that subset of a smaller class that they know you don't have consent for, that they've got the evidence to support their claim, and that they think is much more limited in scope, limited in time, much more manageable, and convince a judge that this class can be certified because they've got the numbers, they've got the account data of when the person was called, and therefore they can sort of figure it out and work it out in the wash. This court may have still pushed against that, but I think if plaintiff had redefined his class, he may have been in a much different position with this judge. His class was way too broad. This court was having nothing of it and was not going to certify it. Not to say that other judges through other parts of the country may and have certified these broad national classes, but this judge wasn't having it. Good for this judge. Great decision for the defense. These are arguments certainly to use to defeat class cert, but I'll tell you one thing that if you take from this case, and the advice that I give to my clients all the time, and it's probably the single best piece of advice I can give to any of them, is that if you're fighting class cert, 9 out of the 10 courts throughout the country have said defendants don't run into this court saying, oh, consent is in such an individualized issue as to everybody's account. Judge, this case is completely unmanageable because in order to determine consent, you'd have to look at every single account holder's records. Well, some courts might say, well, defendant, I think that consent and proving consent is your burden. The FCC said it. The FCC said it, and most courts throughout the country are saying it's your burden, so show us that you had consent for all of these calls that you made over the last 4 years. And if you didn't, you've got a problem. Other courts will say this, defendant, I hear what you're saying about this individualized issue of consent. I agree with you, but defendant, bring something to the table. What's your evidence that you actually have a protocol and a policy to capture and get consent and not call unless you do, and you have the evidence to back it up? Well, it's easy for TD Finance. It was easy in another case, I believe, against Microsoft, where Microsoft said, hey, we only get consent from applications. It's the only way we operate. And here, judges, 1.5 million records of evidence of consent. Sure, it's not everything, but, you know, everything else would be an individual inquiry. And the court said, yes, you've come to the table with evidence. So that is the key to getting out of this case. Is here for TD Finance. I don't know if the outcome would have been different if TD didn't say, hey, we have thousands and thousands of pieces of evidence of consent because we get the numbers from the applications. That's the way we operate. We don't get random numbers. We don't skip trace. We don't get them from caller ID. We don't get them from any third-party sources, from TransUnion, Equifax, etc. We're getting them from the horse's mouth. And they had the evidence to back it up. That helped them pave the way that the rest of this case would be an individual inquiry as to who you didn't have consent for. Evidence is literally the key. So that's it. Let me just get to, I know we're getting right near the end. If you'll indulge me just for...
Yeah, we're right at the, get a couple minutes here, Dave. We're right at the 1 hour mark. So far it's been fantastic. The information is great. We maybe going to get 1 or 2 questions in before we, I know you and I are looking at the same list. Yeah.
I'm going to sneak in a couple questions here, and thank you, Henry. And Henry guided to me some great questions that you all made, and I'm going to try to narrow it down to 2, as Henry will tell you in a minute that we will be able to answer your questions after this conference is over in a subsequent forum or in a subsequent transmission. But let's just say questions very quickly. Someone was asking this: how do we handle recordings in states where party needs to get consent to record? Let me just say one thing on this from a compliance standpoint. With TCPA or any of the statutes that you deal with, any of the consumer, the FDCPA, the FCRA, and you're talking to consumers and debtors and et cetera, those recordings are sometimes the window to the world. Without those recordings, you may not have evidence. I saw one company that lost a case. They did record, but they only kept the recording for 90 days. Did them no good in a TCPA class action, which is a potentially 4-year or longer statute of limitations. So if you're going to record, I would always give the recording warning, especially in those states that require consent. And it's too difficult to figure out which states do require it, which don't. And for you to make sure the collector knows, okay, you don't have to give consent for state A, but you do for state B, it's just something else the collector needs to do. It is too much for them to do. Your protocol should be, on any incoming calls, have a recording warning that is the first thing any consumer or debtor hears when they call in. And it's a recording warning that no matter what button they press on your telephone, that recording warning is going to loop back. It cannot be bypassed under any circumstances. So you know if you got that person gave an incoming call, you can prove unequivocally that our recording system was working on that day. That person called in, they absolutely heard the recording warning. And if they say, no, I bypassed it, oh, no, you didn't, because you couldn't, because we had a protocol and our system is already geared and technologically set up so you can't bypass that recording warning. And then you train your collectors first thing out of the gate when they are making outbound calls or when there's service calls made for any companies to consumers. The first thing out of their mouth is, you say, hi, is Jenny Smith there? Yes, she is. And then you say, hi, this is John Thomas from so-and-so. All calls are recorded. Is Jenny Smith there? So first thing out of the gate, you're already telling the person calls are being recorded. And if you monitor calls, you have to say they may be monitored because you don't monitor every call. And yes, there is no rule that says that you have to do it for, quote, quality control or service observing purposes. It's a good thing to say, but it's a lot of information. Doesn't need to be said as long as your company has a written procedure or a protocol that says the reason why we're recording is for quality, service, or control purposes. Because there's some states that do have exemptions for recording for the purposes of quality control and service observing purposes. So again, it's hi, this is John Smith from so-and-so. This call is recorded. Is Jenny Smith in? So that way you get the recording out right out of the gate, up front and center, and maintain those recordings. Keep them for at least 7 years so that you're covering almost all statutes of limitations. Very, very important, because then it does you no good if you have it for a much shorter period. You're not covering all those statute of limitations. And remember, in TCPA class, it's a 4-year statute, but sometimes from the beginning of a class action to the day that class action gets done, that's another 2 years you're adding. So you could have 6 years of call period. You want to make sure you're covering yourself so you have your evidence, you have your proof. One last question, and I know we got to go here. Someone was asking a question on update on FCC rulings and recommendations for using predictive equipment, manually dialed calls to cells, etc. Look, there are 47 petitions right now before the FCC. Those petitions deal with, please state that any dialer we're using is going to be governed by the word capacity, but present capacity, not some theoretical capacity, because that's insanity, and opens the floodgate to every single piece of electronic equipment in the world to be considered a dialer. That is absurd. So please do that FCC deem that capacity in the statute and in the FCC ruling means present capacity. So whatever our equipment has the present ability to do. Is that the savior of everything? No. Because if the FCC rule controls, i.e. without human intervention, and if someone can argue your dialer has the present ability to dial without human intervention, I don't care the fact that you were dialing in preview or manual mode through your dialer still has the present ability, the capacity to dial without human intervention on its own. You just happen to be using it in that mode at that time. So that that present capacity may not save the day unless there's more to their ruling. They're also saying that, hey, please also state that even if your rule controls FCC, this whole any dialer that can dial without human intervention, please also state that it has to also meet the statutory requirement for a dialer, which is you must have random and sequential number generation. So that is what all these petitions are asking for. They're also asking for an exemption for these reassigned numbers. Very, very important. And because of this, many cases have been successful in arguing to the judges, hey, please stay my litigation, stop my litigation, and let's hold it in abeyance till the FCC rules. One court in California did impose a stay on a case on the dialer issue and I think on the reassigned number issue, and then said, you know what? We reached out to the FCC, and the FCC said they're not ruling in any time in the near future. Sorry, we are going forward with this case, and I'm lifting my prior stay order. So right now, with regard to what is the best thing to do, talk to your dialer companies about dialer solutions. Talk to Noble about potential dialing solutions to see if they have something that can help you with this automated, to show that maybe their dialer doesn't have automation as many dialers do that can dial without human intervention to do an end run around the statute. See what they have and what they can talk to you about. Also, if you don't know that you have consent, absolutely dial that call manually till you capture that consent, orally or in writing. And if you capture it orally, I hope you're recording or you're not going to have the proof. And everything that you capture orally should also be documented in all of your software, whether that be collection or otherwise. I know we could all go on. Yeah, I know we could go on for hours, but we don't have time anymore, everybody. Thank you so much. I'm sorry. And I know you have so many more questions, and we could do another session to focus on those, but I got to turn it over to Henry and back to Noble, and thank you.
Hey, David, thank you so much. It was a great session. I loved your wrap-up. I think you hit some really important key points there at the end. Absolutely, kind of adding to that commercial that David brought up, we absolutely, as Noble, have solutions to all these issues, and very creative in how our customers have used it. Obviously, I don't have time to go into that now, but obviously, but we do have that. At the same time, for those of you who I know personally, I'm going to definitely want to listen to this webinar again. There was a lot in there. It's good for me. It creates value that I am able to bring to my clients. So just so you know, it will be on the website in a couple of days, plus the extra questions that we weren't able to get through. We had about a dozen or so more to go through. We will put those on the website as well. The good news is a lot of the questions that I was going through, a lot of the questions that were coming in, especially the ones early on, I think David has addressed. So most of them, I think, were addressed in it, and David picked up a few stragglers there on the end. But anyway, thank you, everyone. We appreciate your attendance, and let us know how we can help, and we can dig into your individual situations a bit further. And I think I'm going to end the seminar right now. Thank you so much, everyone. Bye-bye.
Thank you all, and happy and healthy. Thank you all, and happy and healthy holidays to all of you and yours. Bye-bye.
Bye-bye.